Thank you so much. Well, as we start, ladies and gentlemen, our first panel discussion, once again, I would like to take this moment to thank all our speakers, dignitaries, our panelists, moderators who have joined us today, taking out time from their busy schedule and joining us, where, as I already mentioned, the best topics that we are going to speak about, sharing some great insights and view. We would make it a very interactive session. Feel free to ask any questions at the end if in case any one of you have any doubts. So ladies and gentlemen, starting with our first topic, that is navigating regulatory landscape, legal challenges in a dynamic business world. So how many of you are looking forward for this topic? Please raise your hands. Almost everybody, wonderful. The first panel discussion of the day, ladies and gentlemen. So let me call out the names of our panelists. Please put your hands together. Today we have with us Mr. Abhishek A. Rastogi. He is the Chambers of Abhishek A. Rastogi. He is a prominent claim Indian lawyer and jurist practicing before the Supreme Court and diverse High Court tribunals across India. A cosmic and diverse experience, having served as a senior equity partner with Khetans and Company. He is commerce graduate from Sri Ram College of Commerce and a member of Institute of Chartered Accountant of India. Over the last couple of years, he has featured more than 500 times in prominent business to share his views. He has authored over a dozen of commentaries on GST, central excise, service tax, and foreign trade policies. His book was reviewed by Shri Arun Jaitley, and the recent book, India at 75, GST at 5, by Union Commerce Minister, Mr. Piyush Goyal. Let's welcome him with a round of applause, ladies and gentlemen. So please come. I would now like to invite on stage Mr. Gautham Srinivas, partner Khetan and Company. He is a partner with Khetans and Company in their securities, capital market and corporate practice group in the New Delhi office. Gautham has advises clients on merge and amalgamations, private equity investments and other areas of corporate law. He has represented investment banks and selling shareholders on various initials, public offering, IPO, qualified institution placement, QIP, rights offering, high yield debts offering, global depository receipt, GDR offering, among others, from both regulations, S and 144A deals. Ladies and gentlemen, let me also mention this. Today he is here with us in this conference. He has traveled all the way from Delhi to join us. Let's welcome him with a huge round of applause. I would now like to invite on stage Mr. Gautham. I would request you to please join us on stage. I would now like to invite on stage, please put your hands together for our next panelist, Mr. Sanjay Asher, Senior Partner, Crawford Bailey and Company. Mr. Sanjay Asher is a senior partner with Crawford Bailey and Company, which is India's oldest law firm, established in 1830. Sanjay holds a bachelor's degree in commerce and bachelor's degree in law from the University of Bombay. He has authored several articles published in national and international publications and also co-authored book on the Companies Act 2013, which was published by CCH, a division of Walters Clovers. It's a pleasure having you here with us, sir. Thank you so much for joining us. Moving ahead, ladies and gentlemen, inviting on stage my next panelist. Please put your hands together for Mr. Dhaval Vussonji, Managing Partner, Dhaval Vussonji and Associate. Mr. Dhaval Vussonji is the founder of the young and fast expanding firm Dhaval Vussonji and Associate. Mr. Vussonji extensively practices in the areas of real estate, corporate debt, restructuring, EPC contract, hotel management contract, international commercial, arbitrate, litigations and arbitrate, private equity investment, and maritime law. It's a pleasure having you here with us, sir. Thank you so much for joining us. And to moderate this session, ladies and gentlemen, I would like to invite on stage Dr. Advocate Harshul Savla. Please give a huge round of applause. Managing Partner, M Realty. He is a real estate developer, a world record holder, and an author. He has completed his PhD in REITs from the prestigious University of Mumbai and is doing his second PhD at RERA from the Department of Law and Mumbai University. He holds the world record for maximum book authored on real estate sector. He has authored and published 18 books. Yes, you heard me right, most of which are national Amazon bestseller. Dr. Harshul is the chairman of Statistics and Research at CREDAI India and at CREDAI MCHI. He is also the chairman of Business Process Automation at CREDAI National Youth Wing. So over to you. Thank you so much for joining us, the entire panelists. Let's give a huge round of applause and begin the first panel, ladies and gentlemen. Thank you so much.
Hello. Thanks a lot. A warm welcome. It's a great gathering on a Saturday morning. So, back in B school a decade back, when we were talking about business world, business environment, an acronym really came up in the first year itself, which was PESTEL. So PESTEL, really these 6 alphabets, stood for, the factors which are responsible for changing business environment. So political, economical, social, technological, ecological, which is basically environmental, and finally legal. So today's panel discussion is principally about regulatory challenges, how the legal landscape is changing and affecting a dynamic business world. So I'm fortunate to have 3 legal luminaries, and we'll be discussing various aspects. The crowd consists of entrepreneurs from different sectors. Thankful to Bagaria Conclave for, having this August gathering. So we'll quickly dive into, the first aspect, and, all of you all, I would really like your views on this. Presently, especially in the last 5-10 years, we've been seeing that both central government and state government is extremely enthusiastic about amending laws, introducing new laws. And that really affects business to the core, because that really, implicates that whatever you've thought with, the Excels you've made, the business plans you've made, completely go for a toss. I come from the real estate sector where, typically it's a changing pitch every 6 months, but by and large, all sectors are affected. So, and you have an experience with various sectors. So what are your views with regards to this enthusiasm of the government with regards to amending and introducing new laws?
Hi, thank you for that, and morning everyone. Thank you for having me here. I think I would approach this a little differently. To be very honest, no one wakes up one morning and decides I will change the law and I will make it difficult for everyone. There's always an inherent underlying reason, and that goes to the root of the whole jurisprudence, right? I mean, change is the only constant. Change may be palatable, may not be palatable, but if you see, for every good change that there is 5 changes that people will complain about. So I would not probably see it as much as a concern it is from the Excel sheet. It's the point that I hear very often. But I think what becomes extremely important is to understand why there is the change. The impact on the change may be across the sector, across a whole industry, maybe one issuer, but you also have to understand that change is brought about to impact a sector as a whole. You're trying to take a step in the right direction, and if there are teething issues for that, so be it. So I always see regulatory change in a very positive way to say that there has to be an underlying reason. Every legislation amendment that comes out invariably has a reason why the change is being made. So I would still look for that strand of positive, why the change is making happen, maybe iterate it, maybe see how best we can get to it. I mean, one of the questions that we will discuss a little later is around capital raising aspects as well. So my take on this is, I would not see as a change as a problem. I would like to see why is it happening. As long as the intent is there from who the legal changes are applicable to, I personally believe only positive will come out of it. I don't think in a country of this size, you can make a regulatory change to dismantle businesses or cause harm. But that's the way I've always seen it. And I think 20 years now, I've always tried to see why has it happened as against, oh my God, it's happened.
So I quite agree with what Gautham is saying, and I do believe, and Harshul, you being in real estate, I think you haven't had it as well as it's going just now, right? So, you know, whether it was the GST complaints or the demonetization or the RERA, I mean, while these were looked upon as laws destroying the real estate sector today, if you looked at it, I mean, it's nothing better than it going for the real estate sector, especially people who are complying with those laws are regarded by flat purchasers as developers who you should go to. So I think this is something which affects all of us, and you know, it's something which is a testimony that you know, the change which has been brought about by the government really has helped people in general. It has helped the businesses as well.
I would agree with Gautham and Dhaval both. Yes, change is life and we need changes. I would only say, for example, RERA, since Dhaval and they touched upon real estate. Surely real estate, RERA was very welcome. Let me take to the corporate laws. I'll just give you one example. I'm not trying to be cynical here, or I'm not trying to be critical here. We had the SEBI LODR regulations of 2015, which came into play on 1st of December 2015. It's around 7.5 years that these regulations are in place. Suddenly you come on 14th of July, you wake up in the morning, and you see whole bunch of changes which are made to the SEBI LODR regulations of 2015. I don't know whether Gautham or Dhaval have calculated. This was the 37th amendment which came into LODR in 7.5 years. It's a regulation which came into play after the listing agreement which was set up when the Securities Contract Regulation Act of 56 was there. So from 1956, until 2015, you took time to develop these regulations. You had listing agreement in between. Fine. Listing agreement was obsolete, was outdated, there was need to reform that. Fair enough, you do it. But after having spent so much of time, you bring out a consolidated, very good governance regulation, and then you amend it 37 times in 7 years. Is this change? I mean, you decide once and for all. What do you require for governance? What do you require for carrying on business? What do you require for capital markets? What do you require in the best interest of the investors? As I said, look, I'm not criticizing here. You had committees after committees, suggestions were there, and you keep amending each time. Every year you amend, or once, twice in a year you amend. Now, FERA transformed into FEMA. Fine, very welcome amendment. Okay, from a regulation, you then get into foreign exchange management. That was the need of the hour. Yes, it was a good suggestion. It was a good change in the foreign exchange management. No issues at all. Hardly, I mean, there have not been as many amendments in FEMA. Of course, there have been amendments, but as which would complicate the issue or which would make business to be done in a difficult manner. Here we are saying, make in India. Here we are saying that, look, inviting everybody to India. My only point is, bring about a change. The change is very, very welcome. I'm not criticizing change. I'm not criticizing any amendments. But I'm only saying that do it in a manner that, look, which is welcoming by the business community, which is welcoming by the professionals, and do it in a manner which is simple to understand and implement.
No, I'm going to on a lighter note, I'm going to have to come in here because you mentioned SEBI. So, you know, I take your point in terms of the number of amendments, but as someone who is, when these amendments are dropped, we've got 12 to 24 hours to figure it out what it means, because there are boards at different levels who just want to know what is it exactly that I have to do. And I know this reaction to what happened in July, because just to give context here, if companies have had fines, then they'll have to disclose it. Previously, we were in a regime where there was a framework, and disclosure was based on the framework that was there. So there was a nice balance of a threshold, there was a nice balance of you take the call. But now I think the angst from the community has been that, are we moving towards a disclosure regime? So I think my response to this point is, I understand that the volume of changes that have come in, I probably think I again will not complain, because in a country like ours where, you know, there's a very small percentage of our people actually trade. So there's a huge potential in terms of the number of people who can get out there on the markets, make the money. So where you are dealing with retail investors who probably will need help, putting information out there to help them make an informed decision would probably be better. I think the amendments that keep coming in, our job is to sort of put out information out there that helps make people sense of it. But I still believe that this should be seen in a way that the government's actually trying to think in terms of what more can I do? So they're at least not taken their pulse of what the regulation is. So I'd see it that way. It's a little, perhaps cumbersome at times, but I would still think that if you tide through the initial hiccups, there's data out there for you to be able to make a decision. And that, I think, is very helpful from a fantastic regulator, because they're giving that information out there. This information is in public domain, so you can sit anywhere in the world and have access to this. So that'd be my take on it.
No, absolutely. So, you know, having contextually relevant laws are extremely important, most of which are archaic. And that, you know, really brings me to a follow-up question on, you know, what we were discussing. Of late, you know, government really talked about replacing the 3 laws, or, you know, really bringing about new in terms of Indian Evidence Act, the Criminal Procedure Code. You know, so from a daily life perspective, from a business perspective, with Indian Penal Code going out and, you know, you having 3 new laws, you know, coming up. So what is the impact do you see, you know, really, and these are major laws from, you know, a day-to-day business perspective?
I'll go later.
So yeah, the 3 new laws which are sought to be brought in, and you know, there may be questions taking a cue from what Sanjay bhai said, whether you needed to replace the whole Indian Penal Code, or could you have just replaced a couple of sections? And I do agree with him that that a law which is stable over years is something far more important than having a constantly evolving or a constantly changing law. Having said this, you know, provisions which have brought in, and you know, the way they have reworded the CRPC also, you know, the Criminal Procedure Code is now called the Nagrik Suraksha Sanhistan, and just to bring out some of the provisions, they say that a person cannot be arrested if he's in excess of 60 years of age unless you have a deputy superintendent of police having approved the arrest. They have recognized in one of these laws punishment in the form of community service, which is important from decongesting prisons. They have, you know, they have brought about new laws recognizing WhatsApp, Facebook, any bullying on that as being criminal offense. You know, the magistrate can take cognizance of these kind of offenses, which were not there. These are the needs of the hour today, which is with the changing world. So yes, I mean, these laws would be relevant to us in even our daily lives. But yeah, whether we needed an entirely new code or we could have done with may still be a question.
Let me admit first 2 things. One is that I don't practice criminal law. And number 2, I have not seen the new statutes, the replacement of IPC, the replacement of CRPC, and the replacement of Evidence Act. Now, having said that, I'm sure that must have been the need of hour because of the social media, because of the progress on IT, because on the progress of the way things are moving especially on the digital front. So I'm presuming that yes, that was the need of the hour, and therefore the old statutes have been replaced by the three new statutes. One is the substantive law, which is the Indian Penal Code, and then the CRPC and the Evidence Act is the ancillary one, which deals with the procedure. So I've not studied the new statutes. In fact, I don't think I even remember the new names of these three statutes. Okay, so I must admit that. But I would say that yes, I'm sure that these replacements were needed and was the hour of the day, and therefore the Parliament, in its wisdom, have replaced these three statutes.
Yeah, thank you very much for that. And to the point, I have not, I don't practice criminal law, so I have probably not read through the statutes, but we've read about these statutes. And I would probably tend to believe here that as long as there is clarity at the levels where these are getting enforced, that what the new law is and the intent, I go back to intent again, the intent why these new set of regulatory changes have been brought on. If this change is for the better, then in implementing it, this whole thing should not be lost. You should not be left with a situation that, at least under the earlier law, I got something, but there is an implementing hassle here. So I think as long as that is smooth, and newer offenses are getting caught, procedure on the CRPC is getting better, then I think the change is welcome. But I'm just hoping that once this actually is out there, it brings about change for the better. I mean, be it regulations on the corporate side, individual side, criminal taxation, be what it may. It's got to achieve the purpose that why the new statute has been brought. And the good thing is these statutes will always have a regulatory intent and a discussion paper around it. So I think that is something that we just hope there are no teething issues there.
So just for the audience, the three new laws such are Bharatiya Nyaya Sanhita Act, Bharatiya Nagrik Suraksha Sanhita Act, and Bharatiya Sankhya Act. So, these are really the three new laws instead of the Indian Penal Code of 1860, Criminal Procedure Code of 1898-1973, and Indian Evidence Act of 1872. So I think clearly having Indianization, renaming, bringing forth new laws clearly is the flavor. Now, we'll slightly change the format. I'll have more pointed questions for individuals depending on, your area of specialization. We'll start with you first, Dhaval bhai. Real estate is your forte. And, I have two questions for you over there. How would you rate the era post-RERA? So, it's been 4 or 5 years. Some call it a toothless tiger. For most, it's the golden solution. But there are still people who are not very happy. It could be legacy issues, which are really getting highlighted in media. And there is always an argument that after RERA, the projects which really started post-RERA, there haven't been as many issues, but legacy issues are the ones which are, really not getting solved. But in the same light, with RERA, there are still consumers who are going to Consumer Protection Act. They are preferring alternate remedies. So what is your take about this era post-RERA?
So in the era post-RERA, I would say that really it has been a welcome legislation. The legislation in India takes time usually for it to settle down. RERA has taken its time to settle down, but the latest what they've got is RERA is entitled to attach properties of developers who are defaulting in order to pay off the customers their dues. And they have now got collectors sitting within the RERA office itself to be able to attach properties, sell them. The state government is able to auction them, collect the money, and pay off home buyers. Of course, this always does not help you close the real estate project necessarily. But I think the intent of the government saying that, look, you take up a project, you have to close it. I think is sufficient indication to the industry as to where this has to go. You cannot be irresponsible. They have ensured 70% monies remain deposited in accounts in order to complete projects. Yes, in spite of this, there have been people who have stolen money from the 70% accounts. There have been, but these are aberrations. The normal developers who are going forward are going on this basis. And like I said at the beginning, these are the kind of developers who are today preferred by the consumers as well. So according to, if you ask me, over time, yes, when it came, it was a shock. When it came, it was difficult to comply. But 5-6 years down the line, I think we are pretty much all aligned to the way in which it's running.
I really like the fact about you stating that there are exceptions which are actually getting highlighted, but by and large, at an industry level, RERA is something which is brought forth good governance. Moving to next topic, which is really around NCLT and IBC. So, the Insolvency Bankruptcy Code and the National Tribunal. There has been a lot of strong views people have had on either side. So some really see it as a speedy resolution. Some really see it as a convenience of writing off all these bad debts and which are running into lakhs of crores. What is really your view about, the effectiveness trends that you are seeing across sectors, not really only real estate, but across sectors on NCLT, IBC?
So across sectors, at least we've seen a couple of initial ones like Binani Cement, and we've seen SR Steel. And really that has helped the banks recover their debts. But on an overall basis, especially in the real estate sector, if you ask me, having a new law run by tribunals sometimes has its set of problems. The government's constantly trying to improve the way in which this law can be really effective. Again, in India, it takes time for laws to settle down and take effect. Of course, the intent of the law is very good. But if you ask me, recoveries on those, except for large listed companies, I don't see NCLT as a real recovery for smaller debts or unlisted or within the unlisted space.
If you permit me, I just want to add
of course.
Dhaval said. You had the era of Sikh Industries Companies Act, which was enacted in 1985. So you had an agency which was BIFR, Board for Industrial Financial Reconstruction. It lived for around 20 years. First 5 years was the fizz period, where certain schemes were approved. After the fizz went away, it became a dead law. Then you had the DRT and the securitization. That lived for around 15 years. Okay? Again, you had to change and you had to bring IBC. Again, in IBC, in the first few years or first 3 years, yes, there were large ticket transactions which did get resolved. And today, everything, every single petition, whether it is a financial debt or an operational debt, it's languishing. Okay? So therefore, yes, let's see as to how it gets implemented. The challenge is that you need more number of tribunal benches in order that it gets implemented in a very effective manner. Otherwise, it will just see the way SICA or DRT Act got dead in some point in time. I would say the best bet is, I'll just make 2 points. One is that there should be an amnesty scheme, which of course it is criticized by several people. But I would say in case there is an amnesty scheme which says, okay, you pay 50% of the amount which is due, but for the next 5 years, you won't get any debt. What will happen is that people may opt for it. You will say, okay, you'll be absolved of your personal guarantee. You will be absolved of all your other fraud tags, etc., and just pay off 50%, end of the story. I think that could help to speedy recovery of the money. Now, even when SICA was there and when DRT was there, 7 states in the country had what was known as the Relief Undertaking Act. For example, in Maharashtra, there was Bombay Relief Undertaking Act of 1958. Very, very short act with only 4 sections. One section said, notwithstanding anything contained in any other law, not only in law, but even a judgment or an execution decree against the undertaking could not be enforced or had to be stayed in case the state government declares you as a relief undertaking. And you got a moratorium period of 15 years, 1 year at a time, renewable every year. In other words, except for the three payments, which is payment of Minimum Wages Act, your Provident Fund Act, and one more statute for labor protection. Otherwise, you are absolved of everything. This was enacted in 1958, and there were 7 states which had adopted this particular statute. For example, in Karnataka, it was for a period of 12 years, 2 years at a time. Now, everybody lost sight of that. And nobody actually bothered to implement it. Or nobody bothered to take shelter under that. And the first IBC petition, Innovative Industries Limited, which was brought about by ICICI. Innovative, we had brought for Innovative and all its subsidiaries for 3 years, status of relief undertaking. And which was then challenged before the Bombay High Court by way of a writ. The client, unfortunately, did not want to spend money at the Supreme Court and spend money on expensive super senior counsels. Otherwise, IBC would have seen a different way. And they went to the statutory appeal, which is NCLT, NCLAT, and then the Supreme Court. Justice Nariman, while hearing that particular appeal, said that, look, why did you leave your remedy when you had tried through the writ mechanism? I may have been able to give you some relief. And IBC would have been a different statute today, both in terms of substantive law and in terms of implementation.
Gautham, I'd like to bring you in here. You've worked with a lot of companies with regards to their journey on capital markets, on fundraising, with SEBI. We have a booming capital market today. A lot of companies are getting listed. A lot of real estate companies also getting listed. So what has been your experience with the regulator? What is the company's experience? And, this is touting to be one of the top 3 capital markets in the world. So, how has the companies reacted to SEBI and, the governances that are laid forth over there?
Thank you. I think nobody is going to sit out there and say, if you have to disclose a lot, they'll not be happy with it. I don't think we as a community are happy to say, if somebody asks me for information, ye kyun chahiye, ye kyun dena hai, ye kar lo, and that's the mindset. So I think in the regulator that we have here, there is someone who understands the law very well, who's one of the best regulators, because if you see the capital markets at the end of the day come at the end of the cycle of when you see all the private equity investments come in as well, and you see the volume of investments that have come in. It's very clear, obviously, that they trust the company, they trust the ecosystem, and they trust the regulator to give you a logical end. So the onus is on the regulator to protect that one retail investor who may put in an application there. So in my opinion, in terms of our regime, it is a very beautifully drafted ICDR regulations. People will argue that it is very cumbersome in terms of disclosure at times, because the regulator's feedback also comes. Some of these questions may be in a certain way. But I believe if somebody from the regulator's end is asking you questions and punching holes at your end, you should be happy that when you cross the line and you become a listed company, you have someone who's done everything that they could to ask a set of questions of you. Because the minute you become a listed company, you're duty bound to your board, to your shareholders. It's not just about running up the numbers. It goes to the root of governance and conscience as well. So I think if disclosure increases, it probably will take more time, takes a little more effort. But I don't think I see that as something bad at all. It may be troublesome, but if you've got to get to that journey, then you will have to go through it. And it's a very simple principle of coming clean. Sanjay Bhai here is someone who's been doing cap markets transactions probably even when I was in law school as well. And if I may just seek his guidance here on this, you've seen this back in when we had the capital control regime and the DIP regulations as well. when you make a buyer beware approach, I mean, we've seen these regulations evolve. The constant focus has always been to put information out there to enable people to make that decision, right? At no point of time, you have global jurisdictions like Luxembourg where you can do an FCCB or you can do a GDR, right? I'll just take a step here, a parallel analogy. In 2008 and 9, when the whole collapse happened, around 2012-13, there were a lot of orders from SEBI about GDR manipulation. A dime a dozen of these orders were out there. All of this happened between 2007 and 8. In hindsight, when you look back and analyze it, there was a lot of thought that went into identifying what the loophole was and misusing it. So if you can make that effort to identify a loophole, then I think you can then make that effort to understand what the regulatory requirement is and be on the right side of the law. I think you will never, ever be penalized for doing something right. I'm a firm believer in that.
I agree with Gautham completely. I mean, there's no harm in disclosing. We had the Companies Act and the SCRA Act in 1956. Come 1992, there were these fragmented SEBI circulars which did deal with the IPO document. But yet, the pivotal statute was the Companies Act. Disclosures were very scanty. The offer document used to be not more than 15 or 20 pages, as opposed to a 500 or anywhere from 250 to 500 page document. Yes, one has to disclose. You have to, there's no harm in that. Now let me give you some examples. Asian Paints, for example, went into public in 1982. The disclosures were very, very scanty because the law did not require. Yet, it has done fantastic. It has given fantastic returns to the investors. And it is the darling of the exchange and the darling of the investors. The point which I'm trying to make here is the business has to be robust, the governance to be implemented and to be followed by the company which is raising money from the public. And it's a very fiduciary and a moral duty that you are taking investors' money and you have to be careful with that particular money and give returns to the investors. So please run your business in a very, very effective manner, both from a business perspective and from a governance perspective. If you see, whether it is Nestle, whether it is Ingersoll Rand or any of these, all those companies came into, or Pfizer or Procter & Gamble, all of them came out and got their shares listed prior to the DIP guidelines came into play, prior to SEBI coming into play. But yet they are darlings of the exchange. They are the ones who are doing fantastic on the bourses. And at the same, why? It's pure and simple. Their business model is robust. Their business is robust and they follow governance to the last possible T. So the point which I'm trying to make here is, A, please disclose whatever is required to be done and maybe you disclose more in the offer document. No investor is going to invest because you have disclosed more and there are too many disclosures which could be considered as harmful in raising money. No, the investor is going to see how robust is the business, how robust is your governance, and then is going to invest. And if the business is robust, governance is very good, obviously, you will get value for that business.
Sorry, on a lighter note, the reason I think I'm sitting here is because we're working on a public issue transaction with the Bagaria team, and I think we drove them up the wall. And Rahul and Hardik are working on the transaction with us. And I think I've left no stone unturned in making their life hell. But I'm not saying this because I'm sitting here, but I'm saying this because at no point of time that what we ask of them, did they say, no, why, extra information, nothing. So when someone who's advising a company as well understands why are you doing diligence. See, there are two parts to this. There is diligence and disclosure. As long as you're clear, diligence helps you. Disclosure is a framework. Diligence is your conscience. So if they both tick and tie, I think we're in a very good place.
Thank you all of you all. So on this note, we will close on this panel. Clearly, India's on the right growth path. Transparency, accountability, and governance seems to be the flavor, and that is how the regulatory landscape will continue as well. Thank you all for patiently listening to this conversation.
Thank you so much for sharing